Welcome back to This is VANCOLOUR. My name is Mo Amir, and we've been discussing issues around BC's toxic drug public health emergency. But whether we're talking about forced addictions treatment or decriminalization, there are many legal implications that have to be considered. So to give us that legal perspective, we're going to wrap things up tonight with my friend, one of BC's most high-profile criminal defense lawyers representing Acumen Law. She is Kyla Lee, and this is Kyla's Court. Kyla's Court is now in session. Kyla Lee presiding. Hi, Kyla. Thanks for beaming in.
Hi, Mo. Thanks for having me from far, far away.
Absolutely. So I think we all understand when something is legal and when something is illegal, but what does decriminalized mean when we're talking about drugs?
Decriminalized is essentially a space between legal and illegal, where in Vancouver and British Columbia's exemption, it is given essentially a free pass under the Controlled Drugs and Substances Act. So people within the rules of this exemption will not be prosecuted for violating the law, even though the law is still on the books.
Right. So is it something like you're technically committing a crime or you're doing something that's against the law, but there's no like criminal proceedings, something like speeding, perhaps?
It's not as simple as speeding, because speeding is still a violation for which you can be punished. You can get a ticket. With decriminalization, there's no punishment for possessing an amount of drugs within the limit on the exemption. The only punishment that you would get is if you went above the acceptable limit that the government has granted.
Right. And another issue that we've been discussing is this idea of involuntary or mandatory treatment. And we know that under, the Mental Health Act, people can be institutionalized if they're a danger to themselves or to others. But legally speaking, like, how are people allowed to be institutionalized or detained? What's the determinant there? And what's the constitutional rights of any individual to not be institutionalized?
Well, everybody under the Canadian Charter of Rights and Freedoms has the right to be free from cruel and unusual punishment, and they also have the right to life, liberty, and security of the person. So compelling somebody into treatment may violate one of those rights, depending upon the circumstances that led them to be put into treatment. But like every charter right, those rights are subject to reasonable limitations, which can include, if the government were to pass a law trying to curb the number of overdoses, putting people into treatment against their will if they have a repeated pattern of overdoses. Whether or not it's constitutionally valid will have to be tested by the courts.
And really quickly, how do we have a situation where drugs are decriminalized, but because of your possession of drugs, you could potentially be, forced into treatment?
The reason for the decriminalization is to try and stop overdoses. So if you continue to overdose, this is what the government is saying, then you can be forced into treatment to try and further that goal that has led to the decriminalization. So it's essentially about protecting people from the danger that the government sees that they pose to themselves. Whether that's right or wrong, again, that's going to be tested in court.
Well, hey, Kyla, I appreciate your perspective, and I look forward to you being in studio next time. Thanks again.
Me too. Thank you.
Folks, that's our show. Thank you so much to Vince Tao and Dave Ham of Vandu, BC Liberal MLA Eleanor Sturko, and of course my friend Kyla Lee for tonight's show. Of course, if you want more, find This is VANCOLOUR on Apple Podcasts, Spotify, Check Media's YouTube channel, and the Check Plus app. For now, though, this is VANCOLOUR, and I'm Mo Amir telling you that in a province where you can be anything, be colorful. Peace.